listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Hi, Kyla. Nice to see you. Oh, you're sick. I was just blowing my nose. I was out in the rain. You're in the office. I can see that. You can see my glorious surroundings.
Yes, you're also in our office, but less decorated as this.
I'm in Richmond. If you decide to come here as a summer intern, you're a law student, you might end up in the windowless office upstairs in Richmond, which sits vacant for the non-summer months.
Yeah, but it's still a nice place to be.
It is a nice place to be, and this office is usually the warm room, and that's the reason I picked it, because I was just out walking in the rain, and I got wet, and my pants are still wet, and my feet are wet, and I picked this office. There's other places I could have picked, but I picked this office just because I figured it'd be warm, because it's usually the hottest office up here.
Yeah. Well, we have a lot to talk about this week. Big news on ICBC's front. So there was a case, I don't know if we talked about it a long time ago or if I talked about it back when I used to do that regular segment on Radio NL on Monday mornings, or both. But it was a case where ICBC denied coverage to a person who was involved in a hit and run, and they couldn't identify the driver. The police conducted an investigation, couldn't identify the driver, so they sued ICBC as the nominal defendant, as one does in those pre-no-fault days. And ICBC rejected the claim, saying they didn't do enough to try to identify who the driver of the vehicle was.
Really?
Yeah, and then the injured party, the plaintiff, appealed that decision to BC Supreme Court, and a BC Supreme Court judge agreed with ICBC and said they didn't do anything to try and, the police conducted their investigation, but the plaintiff never did anything themselves to try and figure out who the driver of the vehicle was, and that's not good enough. You have to take reasonable steps under the Insurance Motor Vehicle Act to identify or attempt to identify the driver of a hit-and-run vehicle.
What are the reasonable steps? Like, yeah,
I don't know.
somebody struck my truck. Somebody struck my truck parked on the front street. I didn't even notice that it was struck. I mean, I might have noticed it 3 days later.
Yeah, you put up a sign. Did anyone see a car accident involving this truck? You take out an ad in the paper. I don't know, make a TikTok video asking for witnesses. That seems to get a lot of help these days. TikTok detectives on the case. Anyway, so they appealed this to the BC Court of Appeal, and the BC Court of Appeal overturned both ICBC's determination and the BC Supreme Court judge's decision, and remitted the matter back to the court for determination of the quantum of damages.
Oh.
So what happened in the background in this case? After the accident, the driver of the truck, the hit-and-run truck, fled the scene. Corporal Gagne from the Burnaby RCMP attended. He showed up about 10 minutes after the call. He knew that the pickup truck that was involved, there was a license plate. He knew it was a stolen truck. So there was no, it's not just like a matter of figuring out that it's the registered owner or someone related to them. It was, and he was aware that the person who had operated the stolen pickup truck had fled. Constable Gagne shows up at the scene, sees Mr. Fearon, one of the injured parties in the accident, and speaks to him. And he says, "Oh, there's a guy in a black and white hoodie and dark pants running southeast in the direction that they'd come from." But he didn't see that person come out of the truck, and other than the clothing, couldn't give any description, and nobody else involved in the collision saw anything at all. There were 3 witnesses. Nobody saw anything. They just heard the crash and called it in and arrived after the fact.
In any British Columbia town right now, there's probably somebody in a dark hoodie, especially between 10 o'clock at night and 4 in the morning. Somebody in a dark hoodie running.
Yep.
From something they shouldn't have done.
Yep. And so The police then conducted like a full, investigation as much as they could. Constable Gagne did things that would be, normally done in stolen vehicle investigations, including getting the police dog service to come and locate the driver. They canvassed the area for video to see if anybody had captured the collision or the driver fleeing on foot. And they did a forensic examination of the vehicle in the police compound, looking for DNA, fingerprints, and anything else that would help identify the driver. But nothing was yielded from this investigation. No dog tracks, no fingerprints or DNA, no description, no video. That's it. There was literally nothing. And so the police called off the investigation because they had nothing to go on other than a guy ran. So that's everything the police did. And you think about it like from the police investigation standpoint, what more could the police have done? What more possibly could have been done in that situation?
Well, they could, did they locate the truck?
The truck was left at the scene.
Okay, well, there you go. So DNA,
Didn't find it.
fingerprints.
Didn't find it. Yeah,
There were video at every different business up and down the street.
there was none.
Found up the usual suspects.
I think the usual suspects are already in the DNA and fingerprint data bank.
No, I mean, there's only so much you could do, and there's also only so much you can do, like, resource-wise.
Remember our colleague who used to represent a prolific car thief who just couldn't help stealing cars? They should have called him.
Yeah.
Did you do it?
Well, I mean, we used to discuss, like, by the time he gets out of jail next time, the technology will be so far along that he won't know how to start the cars being started with apps and things like that. He'll only be able to steal 35-year-old cars.
Yes. Anyway.
It's backward. That's a known thing. Are you going to survive? Are you all right?
I'm struggling, but I'll get through this.
It's a known thing when people get out who had served jail sentences for a long time for car theft, that the first thing they'll go looking for is a car from their era.
Yeah.
No, another thing to steal.
So
88 Toyota pickup truck.
the police also advised all three of the injured parties in the accident that they didn't need to do anything. The police would notify them if they got any information, and otherwise they should just make their claim to ICBC. So they followed the advice of the police. They did nothing. They trusted the police were doing everything they could to try and identify the driver. And the court found originally, like I said, that was not enough. That they, should have put up signs or taken steps to look for this driver themselves. The Court of Appeal basically rejects this, saying, what more could you possibly ask somebody to do when a police investigation, with all the resources the police have for like DNA, fingerprints, dogs, video canvas, all of that, all their databases turn up nothing. Could you possibly expect somebody to do more and undertake their own basic criminal investigation to try and identify this driver just so they could get coverage? That's completely ridiculous. Absolutely.
No, seriously, it is absolutely ridiculous. Like, the expectations of people, they're a victim, right? The expectation of a victim to be able to like conduct an investigation and pull everything together perfectly. Just like, I wonder what they're thinking at ICBC, and again the Supreme Court judge too.
Yeah. So the court, specifically in relation to signs, says, how could that have helped? Even if such persons existed and would have responded to an ad, none did so when the ads were posted. It is virtually inconceivable in the circumstances that they could have added anything about the identity of the fugitive beyond what was already known to the police. There was no real possibility here that it was going to identify the other party.
Unless he confessed.
Yeah.
At which point, would the ad on the poll be the thing that finds the person who heard the confession?
Yeah. The court says it amounted to pure speculation, and the law ignores hypotheticals that are not on the evidence real possibilities. And then says, given that a serious crime was involved beyond the mere fact of a hit and run, it is surely reasonable to rely on the police to investigate it rather than undertake what amounts to a criminal investigation on one's own with the attendant personal risk. Arguably, it would be unreasonable to do otherwise. As Constable Gagné put it under cross-examination, identifying the person would be the police's job. It is not necessarily the job of the occupants. Thus, as the judge included among recognized factors as paragraph 13 of his decision, a plaintiff's duty can be attenuated by relying on others to determine it. So the court basically said, no, if the police are doing the investigation, you can rely on them to do their job, and they'll do it better than you could. And also, they're probably not going to get killed like you might.
Sounds like the Court of Appeal got it right this time. Once they for a change.
No, I don't say for once. That was a joke. I take it back. They've agreed with me at least 3 times.
Well, the Supreme Court of Canada seems to overturn them 2/3 of the time. So
No.
they get one right out of 3.
Until I'm appointed without applying to the Supreme Court of Canada while not being competent in French, I can't do the work of the Supreme Court of Canada.
No.
Okay. Also this week, turning from good news for drivers, we have bad news for drivers. This is this is an IRP judicial review decision that did not go the way of the petitioner. It's Gurtej Singh and the Superintendent of Motor Vehicles. And it's a case involving a refusal to provide a sample. So, what happened?
Kyla, it doesn't sound like you could provide a sample right now. You're so sick.
I should go run and grab the ASD and see if I can.
It's sitting on the shelf in my office right there. It's got a mouthpiece on it.
I know where it is. Let me get. Okay, one moment.
Need a break.
Get through this case. Okay, so this guy's pulled over at 2:05 in the morning. He's got 3 passengers in his vehicle. The officer doesn't detect an odor of liquor coming from the driver. He's steady on his feet. He asks him what his last drink was, and he says, a while ago, without clarifying what that meant. Confirmed he didn't smoke, vape, have anything in his mouth. He was read the mandatory demand. And then he asked, hey, what happens if I refuse to blow? You can see where this is about to go, can't you?
As soon as somebody asks that, even if they are physically incapable of blowing, and sometimes people are anticipating it because they know they have breathing problems.
Yeah.
But they ask that question. The next thing that happens is the superintendent, the adjudicator says, oh, you were planning, it was in your mind.
Yep, exactly. Officer told him it would have the same punishment as blowing a fail. The consequences, 90-day driving prohibition, 30-day impound. Gave him a demonstration and explained how to provide a sample. And he was given 9 attempts to provide a sample, none of which were successful, including 3 further demonstrations of how to provide a sample, and then arrested for refusal and then given the IRP. So he and his witnesses all said, oh, no, he wasn't given 9 attempts. He was given 3. And also he was trying his best to blow, and also he, didn't want to refuse. And the adjudicator rejected all of that, obviously, because that's how it comes up before the court. The adjudicator noted, first of all, that while he swore that in his affidavit that he had a single alcohol beverage many hours before the traffic stop, he provided sworn evidence that he made every attempt to blow, but disputed that he was provided 9 opportunities. And each time, he said, the officer pulled the device out of his mouth. He disputed the demonstrations were given to him, and swore that he followed to the best of his understanding the method to provide a sample, that he wasn't attempting to defeat the device. His witnesses, first one said he didn't drink alcohol for many hours before the police interaction, and that she exited the vehicle so she could observe them. She was standing closer to the petitioner's vehicle, and she saw him blow 3 times. The second witness said he didn't drink alcohol at dinner at the restaurant. He was about 10 feet away Saw him try 3 times. The third witness says she was at dinner, he didn't drink any alcohol in her presence, and, that she watched from the back seat of the petitioner's vehicle and that she saw him only blow 3 times. Um, so the adjudicator basically says that, the "a while ago" response, was vague. Not only had he only alluded to drinking 1 alcohol drink in his evidence, but he also didn't really describe what it was or when he had it. Um,
Specifically,
and his roadside evidence was vague "a while ago," which is vague, which I have a problem with, which I'll get to, and I think you share the problem that I have. The adjudicator also found, as you just uh, correctly predicted, that before any attempts to provide a breath sample, he asked what would happen if he refused to provide a sample, which caused the adjudicator to, quote, question your interactions with the ASD and your credibility. Not sure how that affects credibility, but okay. And that he was given 9 attempts, on the basis of the fact, that the, officer's evidence was very detailed about the instructions he gave and what the petitioner did, um, and, that his behavior was not indicative of someone who was making a genuine, attempt to provide a sample, and then questioned the, opportunity the witnesses had to observe the petitioner because they were further away, than the officer, and so gave little weight to their evidence. So you can see where the arguments on unreasonableness flow
yeah.
from. However, the court does not agree that anything about this is unreasonable.
Oh
Uh,
my God. So much slack given to the superintendent of motor vehicles. It just is frustrating.
so much. The court basically says the adjudicator grappled with the conflicting evidence about whether or not there were 3 or 9 attempts, and found the officer had provided a detailed account of each of the 9 attempts, that the witnesses were correctly deserving of less weight because they had less of an ability to observe the interaction. The reasoning about that was logical and flows from the evidence. Particularly considering one of them was in the back seat of the vehicle. It was 2 o'clock in the morning, so it's not light out. Okay, maybe. Although I still think that's grounded a little bit in speculation. But
So, yeah.
then, with respect to the alcohol consumption, the adjudicator's decision to give little weight to the petitioner's evidence of his lack of alcohol consumption and the witness's evidence was reasonable because it was unclear to what extent the witnesses watched the petitioner throughout the night at the restaurant. You have 4 people who
How
are
much information do you have to give about monitoring somebody else at a restaurant? Just think of the normal interaction at a restaurant.
you're sitting with 4 people at a table. You're watching the 4 people.
Why do you
Big
have to
up to me.
comment about how much you observe the person or how, you get up, you go to the washroom, somebody orders a drink, you take note, they're having a drink. I'm going to order another drink. I mean, like, why do you have to describe how you
You were taking
your
shots only when you were in the bathroom?
Yeah.
It's weird,
But the
but
educators fixate on certain things
they do.
said in
And
the past. And then somebody coming and looking at it who wants to uphold it because they generally want to be able to backstop the adjudicators.
yeah,
It comes back and says, "Oh yeah, this makes sense. This makes sense. This makes sense," without like critically thinking about it. And it's funny because they'll hang on to something. Like I've seen this in court over the course of my life, where I go in, I make some really good logical argument. The prosecutor comes along with a red herring, hammers on that red herring, and then the next thing you know, the judges got the red herring in their mind. And if you actually step back and think about what they're arguing, it's a complete non-issue.
yeah.
But you can distract a trier of fact. And now you've distracted the reviewer of the trier of fact.
It was also reasonable, apparently, to reject the witnesses' evidence because they didn't comment on their own alcohol consumption.
So they their own drinking patterns, therefore they can't have observed somebody else's drinking pattern.
Apparently. Um,
One of them did. One of them commented about it. Anyway, yeah.
And the court says the witnesses' statements about the petitioner's lack of alcohol consumption were blanket statements devoid of detail. For example, the witnesses did not provide details of how long they were with the petitioner over the course of the evening, how many hours the dinner was, what they each were doing over the course of the dinner or evening, or what they were doing before arriving at the restaurant. I also note the statement of the witnesses were not consistent with the petitioner's evidence at roadside that he'd consumed alcohol a while ago, and on review where he deposed he had a single alcohol beverage many hours earlier, but did not provide specifics as to when. And then says the petitioner's and the witnesses' evidence about alcohol consumption was vague, and the adjudicator was entitled to place little weight on it. You get this a lot, right? Clients often will say, do we have to include how much I had to drink in here? Do we have to put those details in? I don't want to include it. I don't think it's helping me. Well, actually, it's going to help you to not be vague.
It's because the standard is parsing your evidence and slicing and dicing your evidence in so many different ways, and the search for anything that they can find to use to reject your evidence in this system where there's no cross-examination. And it's they're trying to get to a certain result, which is to uphold the IRP if they can, without, unless it's going to embarrass the tribunal.
I mean, it really does feel like reverse engineering when you have like all these extrinsic details. What did you do before you went to dinner at the restaurant where you're providing evidence about the events at the restaurant? Who the fuck cares? Like, if you put a witness on the stand, if you
that judge with his first two decisions in the IRP scheme who said it was reverse engineering, he was right, and it's been reverse engineering all along, and it's just been, everybody's blind to it. It's like a legal fiction, but it's like a conspiracy to disregard that this is how it plays out.
yeah.
I hate to say it that way, but that's I'm convinced in it after 16 years of doing this.
Yeah. So the court says the adjudicator on the last issue of the statement about the question, the adjudicator set out the evidence of the officer as well as the evidence of the petitioner and the witnesses and made findings of fact as to what weight to give the evidence. Overall, the adjudicator found the officer's detailed account of you blowing briefly into the ASD, sticking your tongue into the straw, which cut the air supply, backing off the device with your head, removing the seal from the straw, providing brief blows, tiny puffs of air, and continuing to cut the supply off before a suitable sample could register, more compelling and consistent with the status message of the flow INS, and to afford it more weight. That's like 8 different blowing behaviors in one sentence. Like, I'm sorry, if you're hedging your evidence as a police officer and saying they're doing all these separate things, I don't think weight
Some things that are you can't see.
Yeah.
Some things that can happen during the course of a single sequence of a test.
Can you see where somebody's tongue is when it's inside their mouth?
Yeah. Unfortunately, the message has gotten to the police that they get a IRP revoked, and then they go back and look at the IRP to try and figure out what's wrong in there, and then they just craft new lies for the next IRP. And without any independent witness there, and no cross-examination, and no full disclosure, we never get it. And unless we get video, we are going to be in this circumstance over and over again with the IRP scheme, as we have been for 16 years. And it has been totally to the disadvantage and undermining confidence in the justice system, undermining confidence in the tribunal, undermining confidence, of course, in the review process, and undermining confidence in the police. It has been damaging to society in BC as a result of this. And I blame the tribunal for rubber stamping bad police behavior over the years in this manner.
I don't like this judgment too, because it seems to suggest that if you're vague at the roadside in terms of being asked about drinking, which you're entitled to do because you're not obligated to provide information to police, you can say a while ago, and that legally should not be sufficient to reject your credibility because it's an exercise of your right to silence. Your right to silence doesn't mean a choice between speaking and not speaking. It's a choice about how much to say and when to speak and when not to speak. You can say some things and not say others. And like this seems to be completely inconsistent with that, despite the fact that the Court of Appeal even has recognized that too much, great care should be avoided to avoid or taken to avoid an approach that places too much of a burden on a driver to provide an explanation roadside. But I mean this.
But people know that dealing with the police is a dangerous situation. And they've also been like culturally taught that you should be circumspect and you should be careful when you're talking to the police, not careful with respect to accuracy, careful with respect to protecting yourself from getting tasered or what have you. Like
Yeah.
most of the time, people are trying to downplay it, not just because they're necessarily going to try and hide what they had to drink. It's also because of realistic and reasonable fear that people have of the police for very good reason.
Yeah. And then the other thing I think that is most troubling to me out of this decision is placing any weight on somebody asking about the consequences of refusal. Because you and I know lots of people who blow also ask about the consequences because people don't know. People in this country don't know that you don't have the right to refuse. Like, and so people don't. What if I? Yeah. What if I don't do it? What
You're in
like?
Texas or California. I think you're like the instructions are to refuse.
Yeah. So
You're in Kansas, you're going to get some sort of administrative consequence for refusing. But if you provide a sample, you're providing evidence that proves that you're over 80 and you're entitled to refuse. It's
yeah. Like,
there's a motivation there. There's a reward for refusing.
and to infer that seeking clarification of your legal obligations in a situation of a power imbalance where you don't have the right to counsel, where the only source of information you have is the police officer making the demand, to infer that that is a statement of your perception that you'll blow over or your consciousness of guilt, and not just, I'm in an unfamiliar situation and I don't know what is the right thing to do. That, to me, that's troubling. And all of the decisions that have talked about, the limitation on 10B in this context have never suggested that we should interpret that information seeking behavior that way when we're leaving the officer to be the sole um, arbiter of your rights.
We all know that we have a right to talk to a lawyer, and we all know we have a right to talk to a lawyer for the purpose of finding out the legal position we're in. Like that is the purpose of talking to a lawyer. And in those circumstances where your right to counsel is suspended, and so you don't get to find out what the law is with respect to what you're doing, it is completely reasonable for a person to ask the police officer that question. And it says nothing, in my mind, to behavior before or after that.
Yeah. Anyway, okay.
Reaching
Suffering.
though.
And suffering, so let's move on to
The ridiculous driver of the week.
give me a little joy.
Well, the ridiculous driver of the week is, used to very often come from news stories, but these days, so often because of there being no journalists anymore, it's coming to us from TikTok, and I'm very often sending them to you at the end of the week and or through the course of the week, and then we wonder who's going to be the ridiculous driver of the week. The ridiculous driver of the week this week is one, again, I saw from TikTok, and it is Cincinnati police cruiser, two of them, so Ford Explorers, following a suspect vehicle, and somehow this police cruiser ends up on the back of a flat deck trailer pulled by this like full-size SUV or pickup truck, and this driver's driving like crazy with the police cruiser like high-centered halfway on the back of this trailer. And ultimately, I'll show you. It was on the independent dash cam footage of the other police vehicle. Ultimately, there you're watching. This is just insanity. You see that?
Well, that's one way not to lose your suspect.
Yeah. Well, so shockingly, the police officer who's following this police vehicle on the trailer that's being pulled by this other vehicle decides that the remedy here is to go and do a pit maneuver. And so he has to go up past the trailer to get to this truck ahead and do the pit maneuver, which causes the police SUV that was on the trailer to come flying off, flip over, and the suspect vehicle to drive into a tree. Wholly dangerous because there's a police officer now in a rolled Ford Explorer. There was also, so this is just posted on TikTok this week. I held it up. I'm sure Paran may find it and post the link somewhere on our social media. There was one of those Ford Explorer SUVs rolled in Langley this week, police one, and was posted on TikTok. And apparently the officer was taken to the hospital, but is okay, but was in the midst of responding to something when that happened. Pretty wild one. I don't know who the ridiculous driver is. Is it the police officer who gets up, manages to get his vehicle up on the back of the trailer? I mean, the person driving the truck is certainly a ridiculous driver. And then you've got the police officer who comes up and does a pit maneuver to a truck, pulling a trailer with a police cruiser on the trailer. The three ridiculous drivers.
Does it have to be? Yes.
So that's our podcast. Kyla's sick. If you decide that you are going to pull a trailer and get a police cruiser stuck up on the back, obviously you're going to be in trouble after that. So give us a call, 604-685-8889. Find us online at vancouvercriminallaw.com or on our socials, and tune in next week for another exciting episode of Driving Law.